Good afternoon. Well, it's a wonderful Friday. Temperature was 40 degrees a day or so ago, and today it's 69. Go figure. There's no real wind. I mean, 1.5 miles an hour perhaps, and the sunlight's out. It's terrific, and the trees are becoming leafless trees in the Cathedral of Trees. The colors are still here, and this will linger on for a day or so. But the glory of the past few days is behind us. What do we have going on? Well, when I was a kid, I didn't understand what they were talking about when they said somebody was on a busman's holiday, and it basically meant that a person who made a living as a busman was on the holiday on buses and so forth. And so for a guy like me, I suppose following trials, and I haven't been able to follow the most important one that's going on right now that involves Trump, and that is the one in Manhattan Superior Court civil case brought by the State Attorney General, claiming that there are all manner of false statements, either increasing wrongly the value of items or decreasing the value of items. And the focus the last day or so was on the various filings that they make, that is, income statements and so forth, and the state of affairs. And these were used going to and submitted to banks and so forth with certifications by no less than Eric Trump, who was on the stand. And the thing that I think you have to understand is what trial lawyers do with a sensational case to keep that information from the public. Now, how can you do that? Well, in the case of Trump in D.C., in the Manhattan court, the way they're doing it is they've decided to attack the law clerk to the judge and suggest that somehow or other, because she is biased and prejudiced in some way, that she's affecting what's going on in the courtroom. And they came and went at it full-blown yesterday, expecting and succeeding, in my opinion, at getting that to be the story, when the real story, as a matter of the trial, was what evidence the AG got Eric to say on the stand. Now, let me back up. Let's talk about the players, right? You've read all those Shakespeare plays, and they begin with the list of participants. And in this one, the law clerk has become a participant. Her name is Allison Greenfield, and she's a law clerk. Now, a lot of you people out there who are lawyers know about this part of a career cycle, if you will. And a law clerk is somebody usually who does well or is perceived to have certain abilities, is interviewed by a judge, and then works for him, not for a very high salary, and not just for the honor, but for the opportunity to learn how the court system works. Now, I clerked in the U.S. Court of Appeals for the Second Circuit, New York, and counties north, almost to Albany. And but some of my friends work for district court judges. So there's like the district or trial court, and then there are the appellate courts, both in the state and the federal system. So Allison is working for a state court, and her clerkship, I don't know how long it is. I had a 2-year clerkship. Most of the clerkships are 1 year, and I've known people who just loved it and got along with judges who had extended stays as law clerks. So that's what Allison does for the judge. She writes bench memos on difficult evidentiary questions. She researches fact questions. The final decision rests with the judge, but she researches these things so that the judge has considered the difficult issues, and every case has some difficult issue, so that the judge can make a decent ruling. Now, the judge in this case is quite an experienced judge, so his need for instruction is zero, probably, but his need for discussion on an issue he cares about with somebody who is, though young, smart enough to engage in a discussion that may be more law-based than experience-based. We had, when we were clerking among the Court of Appeals clerks, there was one of our number who said he submitted bench memos to the judge, the appellate judge, but the judge complained he never gave his conclusion. And he said he didn't feel comfortable doing that. And we said, well, if the judge wants a conclusion, give him a conclusion. Well, what if he disagrees with me? I said, we all said, that's the point. He can consider what you're saying and decide if what you say and the elements of it compel him to decide that you're correct or that he has to go a different direction. So he finally did that, and he came to us and he was all depressed because the judge went the other way. But that is the prerogative of the court. And that's what's happening with Allison Greenfield. She's making observations, she's making recommendations, she's answering questions the judge has, but she's in his service. And this is a phenomenon across America. And some clerks, it turns into a permanent thing. They become a court clerk. So it varies. Now, what does that have to do with the Trump case? What it has to do with the Trump case is that they're trying to say that because she had her picture taken with the leader of the Senate, that was Chuck, that's it. She's prejudiced and she couldn't possibly decide this case. Now, if she went out there and said, I'm going to do everything possible to affect the outcome and mislead the judge, a whole variety of things, but none of those things have happened. And so, what did they do yesterday? Now, let's go to what I think they wanted to conceal. What they wanted to conceal was a very pointed series of questions of Eric Trump. Now, on these statements of finances and so forth that were submitted and were misleading, let's consider that one of those statements understated or overstated what were the true facts. So there are two questions that were asked of Eric, which are pivotal, and I have to assume they're reported accurately, because it was hard to find this because everybody wanted to write about the easier stuff. But in terms of what's important to the case, the first question was, when you signed this certificate, did you intend and mean that it should be believed by the court? And he said no. He said they didn't have to rely on it. What was he doing there? He was trying to say that the certificate, that what was said was true and considered and everything else, was not in fact the case. Why would he say that? Because what he had to say was false. Now then there was a second question, and the second question was, so, when you wrote this, did you intend to say what was submitted was true? Yes. Now this is very interesting because the contradiction here goes like this. If you have him on the witness stand, and this is the kind of thing that a friend of mine, Posner, takes great delight in. He focuses on cross-examination. I've attended his lectures, and I think he's a great trial lawyer. But he does a real service teaching people how to cross-examine. Now, some think, I think it's partly true, you can't teach a person how to cross-examine. It's more like an attitude. But if you have that attitude, pushing and asking questions, then you can study the elements that make you an effective cross-examiner. So if you have Eric Trump on the stand, and he says, I signed this certificate, but I didn't intend anybody to rely on it, then what you have is the next set of questions. And Larry would like to call these chapters, meaning you draw out the details of the certificate. Well, the certificate here says that everything that's said is truthful, and that It's not false, it's true. And you signed this, right? So you have him saying that he signed a certificate doesn't mean anything, that within the certificate itself it says it means everything in terms of we, the bank, insurers, we expect to rely on this. So that's one lie, and that lie will be understood by the judge. Now, if a jury was sitting there, would they understand that lie? Now, the second question that was asked by the AG's counsel said basically, was the statement true? And he says, oh, I intended it to be true, because he can't intend to have it be false. So he lies that he intended it to be true when he knew well that the underlying statements either exaggerated or understated the property value. So how would you present this to a jury rather than a judge who has spent his lifetime, almost his professional lifetime, studying these questions? You would say he lied in both cases. He lied that the certificate meant nothing because it meant something, and he lied because he had consciousness of guilt that he was misleading the court under oath at the time he said that. But he also said that what he said was true when he well knew that the statement of property was a lie because it was either understated or overstated, just like Cohen said. That's the case. That is the government's case. That the Trump people managed to get lower taxes by understating the value of things and got insurance and debt that they needed by overstating the value that they had so that they could get loans and insurance and things like that. So it's right at the core of the argument. Now, keep in mind that the court has already decided that their statements were false. That's done. The judge has decided that. So what are we deciding now? We're deciding, should they pay $250 million in compensatory damages? And then, should there be sanctions, which could involve additional money? Now, if I'm a judge and I decide based on the record, based on the depositions, based on the exhibits, and based on the answer to these two questions by Eric, who for all intents and purposes was running the Trump family business, I'd say you lied to me under oath at the trial. You told me that your signature, you just sign everything, and it didn't mean anything, and you didn't expect anybody to rely on it. 2, but you said that what you signed, that was true, even though objectively, by you and others, we've demonstrated that it was not true. So you've lied to us twice about two critical elements that have been expanded upon by the prosecutor. So why wasn't that the story? Because, and I hope I haven't been misleading, and in the sense that what I've said is difficult to understand, because it is what Trump's people hope would be the case. Now, I don't for a moment think the judge or his law clerk, Allison, misunderstood what was going on. So the defense counsel, they attack her, the court clerk. They say things about her in and out of court so that there'll be a story about that. Now, when I was a young, well, not yet a lawyer, I was at Columbia Law School, and the Chicago 7 trial had happened. And the question there was, could we get a fair trial? When I say we, I'm talking in the sense of the defendants. And a lawyer named Weinglass spoke to a bunch of us law students at Columbia, and he was telling us what was going on. And my summation of that kind of thinking is that justice is a coincidence of the system, not a consequence of it. And that was more true then and at different times in my lifetime. And it's terribly true right now in cases that are important and those that are considered by the general public less significant. So what they were doing was trying to get a different message out. But I think unlike the Chicago 7 case, the message in this case is to evade responsibility and to diminish the possibility of paying a large sum of funds, and to make an issue not just for the media, but they hope that they can draw upon it to the Court of Appeals when they get to that point. Now, this may sound complicated, but it's not really, because what you have is a kind of a two-step. One, we can't figure out a way for Eric to testify truthfully. And so, if the focus of the story yesterday was about his truth-telling ability, the message in and out of the courtroom would be he's a lying SOB. But if the story in the courtroom is the law clerk is some way or other biasing the outcome and shouldn't be able to commune with the judge, giving him advice, then you're in a different place. Now, this judge, I think, handled it well, and I think it won't affect his view of the outcome. And they hope that by attacking the law clerk and the judge defending rightly staff among a group of misogynists, that he will go over the side a little bit and sort of fulfill their view of what's going on. Now, the Chicago 7 trial, those things that the judge did in response to efforts for the defendants to have their say in court, resulted in all of those convictions being overturned. Now, this is a civil case, not a criminal case. But the concept that Trump follows is more like a mob approach. Intimidate, threaten witnesses, judges, the public, voters, anybody that is relevant to the outcome. So their business is all outcome determinative. And I said that justice is a coincidence of the system. But by that I mean a lawyer in that circumstance where one can't rely on process and one can't rely on the facts and one can't rely on the truth must fight harder using rules that are well established to show that the defense is off on this toot because they can't address the issues in the court, so they make up ones that they hope will persuade people out of the court to continue to contribute to them so the lawyers can be paid. And that the public may support him so he can get elected, because in his mind, that is the only way that he can deal with the criminal cases in federal court. But he has no access to any device, if elected, to save him from the state cases, whether civil or criminal. So that's chaos, is the objective of the defense, and that's not new among Trump and his various battles. And the media goes for the sparkly item and talks about the fight in the court having to do with Allison, but may pass up the important thing that shows the consciousness of guilt of Trump and others by what they're trying to conceal. So does the public want sugar or spinach? That's how I would analyze that whole mess. Now, while this is going on, two short observations. One is that there's a question in Colorado, should Donald be barred under Article 14, Section 3 of the U.S. Constitution? We don't have an answer yet out of Colorado, but the judge will have a ruling by the end of the month, and maybe sooner, but by the end of the month. The other thing that strikes me, which is a stray environmental observation, is that D.C. has a park, Rock Creek Park, and they want to use it for golf, if I understand correctly. That's not my objective to comment on. My comment is that in the bargain, they want to tear down 1,200 trees. Is there no intelligent person on this planet when it comes to the various issues that matter so much? Wrongdoing by powerful, well-placed figures leaving people to their own designs without retribution or correction or punishment when they do something wrong. I feel confident that the judge in New York is up to the task, and that's a saving grace. But when the press misses the story, I say the press, I mean the media misses the story, and they don't cover the kernel of truth that's so important to the Attorney General's case, we're not getting the information about a significant item. Breaking news. It was breaking news, and it was a follow-on to depositions that were given, including Eric Trump's. So, I hope that this was more clarifying than confusing, and to talk about it makes me think I should have written a minor law article about it. But it's as simple as he goes in and lies, and they try to cover it up by bitching and moaning about the law clerk. And that's it. That's the whole story in a nutshell. So I am in my cathedral of trees, and I hope and expect I'll be out here tomorrow to see you. All the best. Bye-bye.